Welcome once again, precious viewers, to the continuation video for Introduction to Equity, the history and meaning of equity. So in the last video, I stopped the discussion, or I ended the discussion with the defects of common law. So there were some defects with common law, and that was what led to the emergence of equity. And those defects were discussed and identified, the major ones, in the last video. Now, it should be noted that those defects were very instrumental to the emergence of equity, because it was as a result of those defects that something happened that led to the emergence of equity. Now, what happened? What happened was that dissatisfied litigants who could not get remedy or adequate remedy at common law started sending their petitions to the king, started sending their appeals to the king in order for the king to do justice. This is because the king had residual power, the power that is residual, that resides in the king to do justice. So the king had residual power to do justice. So it is on that basis that dissatisfied litigants who could not get remedy or adequate remedy at common law started sending their petitions to the king. That was the actions. That was the action taken by dissatisfied litigants. Now the king, as a result of business and engagement with state affairs, could not consider or hear the appeals by himself. The king therefore delegated his power to the chancellor, to the Lord Chancellor, who was a very important officer in the states, to start hearing those appeals and petitions. So the king delegated the power to the Lord Chancellor to hear the various appeal and petitions from dissatisfied litigants. Therefore, it was the Lord Chancellor that hear and determine the appeals for justice that were brought to the king. So subsequently, the appeals, the petition were made directly to the Lord Chancellor and not the king. And it was the Chancellor that was hearing this petition coming from dissatisfied litigants who could not get justice at common law, who could not get adequate remedy at common law. So the Lord Chancellor continued to hear this appeal, and that was how equity emerged. And not only equity, two things resulted from this: the Court of Chancery and equity, which was also developed by these courts. That was how the came about. So, in course of hearing the appeals by the Lord Chancellor, the Chancellor developed into a judicial body. So, with time, the Chancery developed into a judicial body. It became a judicial body, and that judicial body is the Court of Chancery that the Chancellor metamorphosed into. The Chancellor metamorphosed into a court, which was handled, a court which was presided over by the chancellors, by other chancellors too. So the Court of Chancery was developed and it was presided over by chancellors, and they apply different approach in terms of hearing appeal and doing justice. They did not follow the provisions of the law. In hearing the appeal and petition, they did not apply the provisions of common law. Rather, the chancellors decide and determine the appeal based on what is just, what is fair, and based on conscience. They apply the rules of natural justice. They apply moral rules, and they apply the rules of equity to the case brought before them. And the reason was that the office of Chancellor was occupied then by clergies. So it was clergymen, religious people that occupied the office. So they might have been affected by their religious background in hearing and determining the appeal. Now, that is how equity emerged. So the rules applied by the Chancellor to do justice to the petitions, to the appeals, is equity. So they apply the rules of equity both in a general sense and in a technical sense. They apply equity. That's what is just and fair to the case. They decide their case based on conscience and based on equity, both in a general sense, which is what is right, fair, and just. Also, subsequently, the Court of Chancery developed the technical rules of equity. So that's how equity emerged from the practice of the Chancellor in determining the appeals brought before them. They decide the case based on conscience and based on equity. So equity as a system of law was developed by the Court of Chancery to mitigate the rigors and the harshness of common law. So equity thereby originated, was formulated by the Chancery, by the Court of Chancery, and it was applied to the appeal and petitions that were brought before them. So a system of law has now been developed. There is now two systems of law and two contradicting systems of law, which is equity applied by the Court of Chancery and common law applied by common law courts. Now, equity too at its inchoate beginning, that's at its early stage of formation, was not without its own problems. Equity has its own challenge, and the challenge was uncertainty and flexibility. Equity at the beginning has to do with it. Equity in the general sense, there is the chancellor deciding the cases based on fairness, based on conscience, based on good faith. So this fairness, fairness is what is fair is subjective. So fairness is according to each of the chancellor. It was according to what each of the chancellor believed to be fair. That's how the chancellor decide the case on what he believed to be fair. So equity was uncertain and very flexible. In fact, it was it was said to equity was said to vary according to the chancellor's foot. So equity varies according to the chancellor's foot. In respect to this uncertainty of equity, the statement of John Selden is also instructive in that regard. So John Selden made a very remarkable statement regarding this uncertainty of equity. He stated, equity is a roguish thing. For law, we have a measure. Then you have a list there. Equity is according to the conscience of him that is chancellor, and as that is longer or narrower, so is equity. So there's a statement regarding the uncertainty of equity. There's an instructive statement by John Selden, because for law it is certain, as it has been mentioned earlier, that common law was very rigid. It was so rigid and certain that okay, this is what the court will say about this particular thing. But for equity, it varies at the chancellor's foot. But there was a major cause for that too. What was the cause for that uncertainty and lack of systematization? Equity was not systematized. So what was the problem? The problem was because the chancellors too, the early chancellors were clergymen, so they did not also keep record. They did not keep record of their decisions and proceedings. So equity too was not formalized, was not systematized, because the chancellors were not was not organized, an organized system of law, since the chancellors were not legal practitioners. They were not they were not people that study law. They were not lawyers. Now, there was, due to this unsystematization and unformalization of equity, there were petitions. There were petitions and criticisms on equity as a result of its uncertainty and unsystematization. Now, subsequently, equity was formalized and systematized when lawyers started occupying the position of the chancellor. So subsequently, lawyers started occupying the position. Example of such a Lord Chancellor, the position of Lord Chancellor, we have example like Sir Thomas More, Lord Asbury. So there are examples of lawyers that started occupying the position of the Lord Chancellor. So it was during their period that equity was systematized and formalized, when lawyers started occupying those positions. Now, we have the next important point is the jurisdictions, the three jurisdictions of equity. So equity has three jurisdictions. The jurisdictions, they are actually the areas of intervention of equity. the approach, how equity intervene to mitigate common law, those rights developed by equity, the approach taken by equity, they are regarded as is reduced into what is known as the jurisdictions of equity. So there are three jurisdictions of equity: the original jurisdiction, the concurrent jurisdiction, and the auxiliary jurisdiction. But I shall not be discussing that in detail, because that will also be discussed when you'll be looking at the maxims of equity. But what is important to take note that is that the original jurisdiction has to do with the creation of new rights by equity. So right there, we are not hitherto recognized by common law, we are recognized by equity. Then the concurrent jurisdiction has to do with the creation of remedies, new remedies, to supplement the remedies, to supplement common law remedies. Then the auxiliary jurisdiction has to do with the creation of new procedures. So when you will be looking at your maxims, you will look at that very well. So that's the three jurisdictions of equity. The next point is the conflicts between common law and equity. Conflict between common law and equity. That's the next point we shall look at in the next video. So we shall stop here and continue in the next video with the conflict between common law and equity.